That's why free 1 week time for amendment.
Some three.
Yes, Mr. Order dated 9/4/2025.
So I'll pass it or I'll give you time.
Great.
Yes. Next. Or call the list.
Nah.
Right, yeah. You just give me a number. I mean, you please wait.
Supplemental list, item 1.
My lord, item 1, my lord, some defect is there, so I will pay 2 weeks only time, my lord, and I comply the defect, my lord.
Fact, my lord, that item 1 is all virtually introduced. Item 1, the first item,
Yes.
that is 33700. They have challenged the order of mutation. Against that, they have also filed an application appeal. my lord.
Appeal, right? Statutory appeal.
So automatically that application will.
And more so when you say something before the appellate authority that a writ is pending before the High Court, they will not take up the matter. Usually what happens? They will not touch it. Then how?
No. In the second matter,
Second matter.
they have taken stay.
Stay in High Court.
For further proceeding of the mutation appeal.
No, this is in conflict with each other actually. You after
Either of
the
the way,
mutation appeal authority will pass a order, you challenge it before High Court.
My lord, in second case, my lord, mutation appeal is pending before the sub-collector, my lord, which
Yes,
is stay, my lord.
Survey Settlement Act.
Which is stay, my lord.
So stayed for what?
No. The ROR published, directed to be recorded in their name. That was challenged in the first writ application.
Correct.
In the meantime, they have I am for the opposite party and the petitioner in that case. In the meantime, the opposite party filed an appeal before the sub-collector, challenging the same. Now, the record of tenant, they have filed the writ petition and obtained an order of stay.
This is the recorded tenant can very well go to the appellate authority and place his grievance.
No, move appellate authority ki. Semana record tenant.
Correct, right.
On what ground they have challenged the appeal?
No, exactly.
Which stay.
I'm saying that.
Let them satisfy your.
No, that is not. This is not at all to be adjudicated and spend time in this sense.
No.
Recorded tenant's anxiety. Recorded tenant's anxiety that he has a right to property. As far as the revenue records are concerned, that is how he comes to the High Court. That is fine. But the adjudication before the appellate authority as per the Survey Settlement Act, it can well take care of that.
First of all,
So your right to be heard in that proceeding will be protected by this court. What more you will want? Otherwise also, let us assume otherwise also. Can this court step into the shoes of appellate authority?
no.
The answer is
Here,
no.
my lord, first of all, my lord, who is to file the appeal, my lord?
No, you are not getting it. Again, you are going to the. If you
Your
ask that-
lordship is right that since.
No, Mr. Nanda, that is an argument against you. If you raise this question before this court, then the same question has to be answered by whom?
By the appellate.
Yes. It's as simple as that.
Apart from that, my lord.
So all contentions are to
Yeah.
be kept open. Appellate authority has to hear you. So that is the best order you can get, maybe before the High Court or maybe obviously this will go to the Supreme Court because it's it can't go before the appellate
Yes,
court.
Here, what happened, my lord, during while the mutation appeal is pending before the sub-collector, he has filed a suit below. with a prayer for declaration of right title in case.
So there you take appropriate step for registering the suit.
Yes.
For registering the suit and participating in the appellate proceeding before the sub-collector.
Again.
They may be related. But what order can be passed in this writ petition? Best order, according to you, by this court. Can the writ court non-suit the person there? Can the whoever is the petitioner?
Yes.
In the CP, civil proceeding, whoever is he can be non-suited. Written statement, can this court impact? Answer is no.
No.
Before the appellate authority, definitely you have a say because you are saying that I am an interstate party. They may resist it. Suppose the the appellate authority in the survey settlement proceeding non-suits you by depriving you of your right of hearing, then you can very well come. But then it can't be presumed that you are prejudiced by a simple pendency of a proceeding.
Maintainability of the appeal, how can they challenge here?
So that I asked Mr. Nanda is a smart, so he.
No, no,
said
that-
so fair
no,
enough to
that
say
is
that he
altogether-
could argue.
That is altogether different, since he has no right over that property, that suit has been filed after the filing of the mutation appeal.
Sir, lawyers will take recourse to all available proceedings, including 220. That is another aspect. CPC, Survey Settlement Act, 226, 227, all lawyers will, it is well within their prerogative. So there you cannot have a grievance.
তাহলে ଆଉ ଦିନକୁ ଆସିବେ।
ঠিক ଅଛି ଆପଣ ଆଉ ଦିନକୁ ନିଅନ୍ତୁ, but don't keep it pending here.
ନାଇଁ ନାଇଁ
My
ସେଟା ତ
concern,
ଆଜ୍ଞା-
my concern is that when I find,
Yes.
both as a lawyer or as a judge, that matters are kept pending on a road to nowhere. If I can decide it today, I will decide it. Suppose I adjourn it for 2 years.
No,
I'm
The same
I'm
order.
telling about me. I'm telling about me.
yes.
I'll pass the ultimately the same order, and all of you will be waiting on that something will happen. That is no, that doesn't. That law.
Because of the fact that the mutation case, so moto mutation case was registered by the Tahsildar, which does not provide in the statute. Aggrieved person has to file an application. So moto. That's why the appeal was filed. That the Tahsildar has no jurisdiction to initiate the proceeding so moto.
And
That appeal
and,
was
and this revenue law has a history of early 50s or maybe. These were under the civil jurisdiction of civil courts. Gradually, they have shifted to revenue court.
by virtue of that special.
So revenue courts, exercise those powers now.
Yes.
So that way also you have to look at it. Now suddenly coming to read court and getting a stay, I think it's not exactly helping the litigants also. Your client.
Again.
So list on the next sitting as requested by the learned counsel for the appearing parties.
Yes.
Mr. Padhi, you are saying removal of defect. Mr. Padhi, the petitioner, learned counsel for the petitioner. Upon first case search.
Again.
So first case submits that he may be granted further time to remove the defects where is allowed. Second matter, Mr. P.K. Nanda for the petitioner. Opposite party, Mr. Mahanti, AGA for OP number 1. Ms. Mahapatra for
OP number 8.
OP number 8. It is largely agreed that it is by and large agreed at the bar that the petitioner as well as the other appearing private respondents, opposite parties can participate in the pending proceeding in pending appellate proceeding under the Survey Settlement Act. The learned
Under the
counsel-
mutation.
Mutation manual is the executive instruction.
No, again,
That-
govern house by mutation.
Manual is but that provision that you achieve. The mutation manual le bhi refer kara hai.
appeal rule
Appeal
ହଁ ସେଇ ସର୍ଭେ ସେଟଲମେଣ୍ଟ ଆକ୍ଟ କୁ ନେଇକି
ନେଇକି ସେ କରାଯାଇଛି। Survey Settlement Act read with the mutation manual. The learned counsel for the Mr. Nanda seeks for some time to obtain instruction. List on the next sitting, liberty to mention. If you accept that order, Mr. Nanda, you can mention it. I will take it up at 4:50.
right.
So let us not keep it pending.
Yes, yes.
Perhaps you don't understand my anxiety because now this matter has been marked by the Chief Justice to me.
ଆପଣ ବି କାହାକୁ ପକେଇ ପାରିବେନି।
I cannot, no, you cannot go to the other.
ନା ଆପଣ ବି କହିଦେଇ ପାରିବେନି ଯେ ରେଗୁଲାର ବେଞ୍ଚରେ
Regular bench I mentioned before Chetari because now I was looking at the note by since the recusal of the learned judge,
Oh, wow.
senior judge, so it has been marked to.
Fine.
So yes.
item 2
Objection.
Mr. Sethi?
Interim
Yes,
order-
Ms. Patnaik?
interim order to come.
Interim order to continue. Note as I have to work out.
Aye.
Non-compliance of order dated 7/12/2021.
So you have filed consolidated petition
Sorry, ma'am.
amending the parcel.
Already amended. On 15/5/2025, consolidated procedural also filed.
Please serve a copy on the agenda.
copy ଦିଅ
Copy भी दिया है ये चीज।
ନାଇଁ ତ ମୁଁ ଦେଖୁଛି
Copy भी दिया है।
ଗୋଟେ extra copy ଦେଇଦେଲି
Ms. Patnaik appearing on behalf of Mr. Sethi for the petitioner submits that
My power is Chief. First
Item
one.
3 item 2 the Lord Council Mr. Savita Kumari Patnaik for the petition submitted by Ms. Patnaik that inadvertently her name is not mentioned in the cause list. Registry shall indicate name of Ms. P.K. Patnaik with the cause list as well as the case brief. Case brief to the check up. In the case brief. First one. Second look onto it is submitted by the Lord Council that she has already made necessary.
शालिनी पंडित नाही.
अच्छी. Appointment on rehabilitation assistance scheme.
And she has already the amendment in the source. The restriction the commission to obtain instructions regarding compliance of the order.
Well, the appointment on the rehabilitation assistance scheme since 2021. This means waiting for appointment by not.
But after that Supreme Court decision and graduate so please obtain instruction regarding.
And in the meantime,
List on the next city, we got it too much. 2 weeks time, 2 weeks time.
आपका सब फिल्म दे दे ये गोटे
Or the thing is, if no plan or if you share with your lawyer, that will help you to obtain instruction. Which you attach what is happening, in a content petition, there is no application of the. So scope also. Supreme Court has said so.
here my lord.
So when you say these things, he is not aware. Because in counter to they can't give a counter that justifies or not. Either they will comply or case. For instance. So there this helps. This is my understanding. And if you exactly tell them that what has happened, they can obtain instruction. But that is between our level of the lawyer. I cannot forward them to explain that why not to comply. I don't get comply. It will be an impossibility to comply. Can I record that she's saying that some of the.
no, I'll do them. Item 3,
Yes.
May I please your
Yes.
lordship? At the last occasion, Honorable Court has directed to implement
Your
the
name, sir?
Saurabh Das.
Saurabh Das.
Yes, sir.
Saurabh Das, on behalf of the petitioner. Submitted that. Take it's not the right to obtain to bring the amendment to prospect. The amendment prospect to bring on the top of present income. As grateful, please say, because it is much.
Grateful.
item 4,
So, what are you going for the? You are not good at. I. So I remember that. Further time granted to bring the candidates prospective to bring on records of present income.
item 5,
Are we disposal of the mutation case pending before the London Tahsildar?
So, these matters are always directly going to obtain instruction. They say that it can be disposed of. You obtain instruction.
yes, ma'am.
Mr. B.K. Polda for the petitioner. That you took a dash to it. So, one of the reaching for the state. The running cost for the petitioner submits that the petitioner there is a limited remarks because saying that his petition before the opposite party authorities.
OP number 3.
If pending since 2000.
26
Mutation.
ଦୁଇ ହଜାର ଚବିଶ ର
Case number ତ କହିଥିଲି 230.
Can you say that it is kept pending? This one case automatically it will get disposed of if there is no complication. But if there is complication,
Notification.
case number 330. Like AGS and applications regarding the timetable for disposal of the application case. And if there is no other event notification, during the time when this can be disposed of, the same notice is time disposed of. Yes.
item 6,
it is for instruction matter or this
Here you don't have to file counter because it's the part of it. Say simply that it's a career. Item 6.
7,
Adjourn.
8,
So this is the for the petition. So we answer the state. We Mr. Mr. Devan on the state. What is the last bit for this? The matter is adjourned, we wanted to mention.
right
This is not specific as it is, the regular. We wanted to mention. As this is what else.
9,
Please give us the time for your next week.
You are on record, what's your name?
Sanghamitra Das.
S class. It says class for this is class. This is class for the petitioner. So we want the AGA for the state and class for the petitioner 6 accommodation. According to the practice action, according to mention for this period. Yes.
10,
For us, see there. So I think this is a different report, when you compare the petition.
platform nila not received.
The matter of concern that though the matter at least we're pending since 2023 by order dated 11/12/2023. What will it be? The report as granted by the 11/12/2023 order is yet to be received from the SDPO. The Hon'Ble on account of GS understanding will appeal the report. The question is able under the start triangle. This is uploaded. This on the next city, wherever there are lazy problem. You look at the order dated next.
11,
The one asking assistant is assistant, the assistant is interest of special group, the books are acquired. By nature, which is three side independent as significant that for the time is required the completion of the trial. Accordingly, the time for completion of the trial is extended. The end of August 2025. The orders shall be communicated by the registry to the order of action strictures of the Sahoo. Yes, next.
12,
But here,
12 actually. This has to go before the regular bench.
yeah, this will go, but IA 25, IA this 10. This is one matter what your lordship has to perform in order to recall the order because it is not an ancillary to the main prayer made here. This is an independent proceeding, but thinking that is an IA ancillary to the main prayer, since the main bail petition was withdrawn, your lordship disposed of all the case. So for technical reason,
I've gone through that, but there is no case matter for recall. Challenge that is valid.
Supreme Court.
This matter should go, not later.
No, the whole point is that the way it is neither hard nor taken up on merit, the manner it should have been taken. But incidentally, because your lordship probably with the, I mean, in a haste manner, because they wanted to withdraw the petition on my filing this petition, hurriedly it has been disposed of. As an IA ordinarily arose from the main case, and your lordship knows all the IAs are which is filed. If it is ancillary to the main prayer, then only the IA is maintainable. But this IA is exclusively in a separate statute, on a separate provision and a separate law. This has to be admitted for taking of the matter for its legal and logical purpose.
Yes, 3/1/20.
No, I have this IA 10 of 2025.
The other difficulty that doesn't want this matter to be placed in court.
This matter, it has to be, it has to recall, this has to be done. The other matter may go.
But see, does he?
Now, this matter, technically, the whole point is that the Registrar General said something that this matter has to come. If your lordship will say that put up before other bench, then it may go to the other bench.
So since recall of my order, I have
Yes, sir.
no ban on that. But he doesn't want that I should hear his stuff.
It is better, man. Since it doesn't have the matter relating to his other cases, which are main cases.
Asking of that order by the Supreme Court. So these has to go to the regular bench. That earlier order has been clarified by the Supreme.
No, recall order, I think it has to be by your
It's
lordship.
not recall.
Yes. The other IA has to go to regular bench, and the identical matters was also listed. There, the notice has been issued in another case, 340 case.
Yes.
That is there. That matter is that another IA 18 of 2025 that will go to the regular bench. In fact, that was mentioned there.
I need number 10 of
This matter, your lordship may allow it and recall the order. Otherwise, technically, the petitioner will be very harassed.
Okay, 10 I am not recall. Because 10 we are sitting of order cases.
That IA filed under section 340 without hearing, without taking into consideration in its own merit, thinking that it is a IA of the main case, because main case is gone, this case is also gone. This case has not been decided on merit, as required to be decided on section 340 CRPC. So because after filing this thing, the bail petitioner became nervous because the manner in which false affidavits are filed, he never imagined. And we also, in my 45 years of around practice, I never saw filing false affidavit in the High Court to this extent. We are very much scared to file a statement on which is incorrect in facts. Here there are number of false affidavits, and absconding for years together. The police could not get them also. Ultimately, with much difficulty, they could catch hold of the accused persons. And this 340 has to be, there are number of 340 and another identical, another bench has already issued notice, another two matters. Here only your lordship, technically the authorized I will be in a fix. I have filed another petition, but technically I will be in a fix. Since the lordship has not heard it, and yes,
You have filed another petition.
abundant caution we have filed. What can you do?
In the pending petition.
That is that 10. Sorry, the around 18. That your lordship will not consider. That is wrongly also it will come for modification of the order. That is not for modification of the order. That is another 340 petition. So once this order is recalled, that other petition will mark with this thing, or that will we have to withdraw.
So you want modification of order number 16. That's it. 23, 12 to 24.
In IA number 10 of 25. Yes.
To the order date.
Yes. In IA number 10 of 25, we have asked to recall the order dated 23/12/24 regarding disposal of IA, not the other person. Regarding disposal of IA 1-1-3 of 24, that we have prayed to recall, not the main bail petition. Main petition, they have the right to withdraw, they have withdrawn. But this bail petition is not filed by the petitioner. This bail petition has been filed by the informant. So thinking that in that way, your lordship, since the main case is gone, all IAs has to go. If the IAs are filed by the main petitioner, the bail petitioner, then your lordship's order would have been justified. But that petition has been filed by us under a specific statute, which needs to be examined, and it's a serious offense. In fact, the Honorable Court so much should have taken cognizance of filing such false affidavits. They are plain, this is a mockery of the court.
Actually, I was getting that order.
23/12, madam.
23/12 I have copy.
Yes.
23/12 I have copy.
Yes.
IA in which paragraph? Can you find it?
Yes, IA in I have stated.
Can you find it?
Yes. Paragraph 6 I have stated.
No, order 23/12, 24.
Yes.
Which part you want modification? That
In fact, recall, the IA number 1-1-3 of 2024 may be restored to 5. That's all.
So that order which you want modification, which is that order and
Then the modification, in fact, not the order which. Yes.
Because it's part of the order.
Yes.
So which is that order you want because that
The disposal jota kole IA 1-1-3 of 24 taka.
Sir, 2 page 2 paragraph 2.
Se order taka. Se order taka. 23. 23. Last paragraph 11.
Take
11 man.
data here.
Last paragraph.
So which was the petition 340 petition?
That is IA 1-1-3 of 24.
1-2-1-3.
Man. Arising out of BLFL 14425 of 23.
Any number 8 of 2025. The Ali has been filed by
Informant opposite party.
this has been assigned to this page.
Yes. Not assigned. This is on law. It has to come to your lordship.
Ali number 10 of 2025. Arising out of the number.
14425 of 23.
This appeal number 14425 of 2020 disposed of as withdrawn on 2024. Mr. HS with withdrawn for the
Informant opinion number 2.
for the petitioner informant. The petitioner in the ID to bracket informant.
Opinion number 2.
Devraj Manti,
Yes.
which is for the party. So Mr. You are there for the so DP Mr. for the
My lord, the client has taken away the brief, so I am no more holding power in this case, my lord.
ठीक है. The IA has been filed for modification of order dated so and so. Order dated 23/12/2024. Passed. Partly with regard to IA number 1213 of 2024 in connection with arising out of BL-APL number. Arising out of BL-APL number 14425 of 2023. By the state order dated 23/12/2024. The following was directed. Para 10 and 11. When it comes for the petitioner submits that the said orders need to be recalled in view of the grounds stated in the IA. Having gone through the IA, this court is of the opinion that there is no case is made out for recall of that order. Dated 23/12/2024. It is submitted by the learned counsel further submitted that IA number 18 of 18 of 2025. Sure to Namu
18 of 25. Copy is not.
My
prayer.
Copy of the petition not.
ଆପଣ ବି ଦେଖିଦିଅ.
ହଁ ଦେଖୁଛି କପି ଅଫ ଦ ପିଟିସନ
ନାଇଁ ସେ ଆପଣ ଏଇ କୋର୍ଟ ବ୍ରିଫରେ ଦେଖନ୍ତୁ.
ହଁ ଦେଖିଦେବି
ଏବେ ତ ସବୁ ଆପଣଙ୍କ ପାଖରେ ଆଭେଲେବଲ ଅଛି.
ଦେଖିଦେଉଛି
18 ଟା କହୁଛନ୍ତି
ହଁ ଠିକ ଅଛି. 6/1/2025 ମ୍ୟାଚ୍ କରୁଛି ତ. Digital file has this difficulty. At times you are not very sure that 6/1/2025 18 টা. What is the date of 18?
18 हाँ 6/1/25
Mr. No, Mr. Mishra should be sure.
ନା 661 କଣ
डेट
Date,
फाइल
date,
फाइल
ଫାଇଲିଂ ଡେଟ୍
The affidavit date, prayer date,
Affidavit,
whatever you call it. Affidavit date also. Check it.
affidavit will send back
61
6/1
The IA filed on 6/1 filing is on पड़ीगला. Filed on 6/1/2025, supported by affidavit dated 6/1/2025 by the informant. By the informant is on
opposite
record,
pad number 2
being to be moved before the assigned bench. They submitted that the petitioner in the IA apprehends that due to disposal of the earlier IA number
1213 of 20
1213 of 2024 1213 of 2024. A prayer made in the IA 18 of 2025 may be impacted. And as a matter of abundant caution, the IA number 18 has been filed. Apart from filing of recall of order dated
23/12/20
23/12/2024.
in respect of the IA 1213 of 20.
In view of such submissions, it is clarified that the disposal of the IA 10/2024 shall not influence the IA number 18 of 2024 in as much as the IA has been filed subsequently and been taken up by the assigned bench for consideration on merits.
This disposal shall not stand on the way of the
Same language. What you are saying, almost similar language I have
Right.
dictated down.
This it should not stand on the way while disposing of that man.
No, I have said for language for
Influence. Stand on the way, your lordship.
Influence is correct word. Because if I can
influence
direct
slightly.
my brother judge, I cannot.
No, stand on the way, no, because
So,
because either it will be act as res judicata or it will not. So influence is something different. The averment it will stand and not stand in the way.
let me correct the order
Right.
because correct.
Your lordship kindly consider to write.
No, stand in the way directing a judge is not a good thing. By a brother judge.
So then otherwise the whole point is that
No,
some.
because you see, you may, as I said, that you may challenge that order. That's one way of doing it. But since you have filed a subsequent petition, so that apprehension is that it will influence that decision. That is how I have said it.
No, influence. The whole point is it's not a judgment that.
See, I'm not, that when that bench is taking up, I'm not. Obviously, I
The
cannot.
whole point is that law is law. The whole point is that once a petition filed and your lordship said it's disposed of. Disposed of means it's gone. So right or wrong. The whole point is that it will stand as a res judicata and they may raise a question in the other case. The similar petition is already disposed of.
Please consider. You have to then say that I considered and disposed of it on merits. There is no determination on merits. I don't have to assist that way also.
Madam?
Earlier disposal is not on merits. Then
No. Whether merit or not merit, it amounts to dismissal means dismissal. If your lordship said what your lordship says in that 23/12/24.
I think influence is the correct one.
I can only pursue the my thing.
Correct.
Ultimately, what can I do?
Correct.
But the whole point is that the छोटे जिनस that will unnecessary सेठी argument now hearing none of the जिनस stand on the way college भी किसी असुविधा नहीं. It will not stand on the way that the observation no one is affected.
Yes. Yes, next.
And that another matter 29 IA is there.
At 29 in this.
No, yes, that is small correction.
29 is in at civil number 12.
Yes, yeah. Another IA is there. 29.
Just let me get that file. 29. 29, Mr. Mohanty, flag K1.
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 In fact, I did not submit that he has objection to the petition of moving bill before this honorable court, and the honorable court refers
So
without
that
that.
modification I cannot make. I have to then it amounts to review of that order. Even I can't remember also. That is better you not. It is not on anything on merits.
If this nobody can say, unless I am an idiot, I cannot make such a submission. My lord, how can it is a law gives 1 to 5,000 application, and how can I say that I have got objection the petition of moving for bail? How on earth I can say? This is remembering it not inadvertently it has been written.
IA number 29 of 2025.
It is inadvertently your lordship has written it. Milord bail application तो कौन 1000 का fact होगा.
Petitioner has filed. The petitioner has filed the present petition for.
It is not review this
for correction within bracket single quote लिखे correction oblique modification of order with the following prayer. Prayer का quote कर देगा.
Your lordship has said from my mouth that I have got objection. I did not object. He has objection to the petitioner. Immediately I filed. He has got objection to the petitioner moving for bail. Why should I object? Let him file 1,000 times, million times. A person is entitled to file indefinitely till he is in custody.
Having heard the learned counsel for the petitioner and considering the prayer, this court is not inclined to make any changes to the order, said order dated 23/12/2024. According to the said petition is.
I have said so.
That I cannot recollect, Mr. Misra. I cannot. I cannot.
I have stated on the affidavit that I have not said so.
And that is again nothing on merits as far as it is a submission of a lawyer I have recorded.
I have on affidavit I have said so.
No, that I cannot.
That the whole point is it needs
that I cannot because then I don't know. Remember actually. The other side has to.
Again, how can a lawyer have, in your lawyer's practice, has he ever heard a lawyer will say that a petitioner, he will object that he cannot file?
That I cannot recollect now.
No, it doesn't need any recollection, man. It is inadvertently it has been written.
Could be, but modifying that after so much of time, it's not possible.
This idiotic statement will be there from my mouth.
No, it is not part of record. It's
a part of record. It's a part of order. Your lordship has said something which I have never said. How can I say?
I cannot.
I will say that I will say something that a person, even if found guilty 302, he can be released on bail. He can be acquitted by giving 2 kilo of brinjals. How can I submit like that? And the court will record like that.
Examples may be examples, but I cannot. That way I cannot modify the order. Because
It has to be recalled. This order is not warranted.
even that particular.
This order is not warranted. This order is not warranted.
But I cannot recall that.
Why you cannot recall? There are so many orders are recalled.
You see, I have passed my order.
But your lordship is making me an idiot.
No.
Yes, I will say that he has objection the petitioner moving bail before this honorable court. Court afresh without adopting the proper procedure of filing bail. Why should I object? After 45 years of practice, I will do this, and your lordship will record this, and somebody will show someone outside in the court that he is a lawyer. He can make this
So
type of.
even you say that he has objection also. The correction you want is also you said he has.
Yes.
Objection. The same thing you have said. Nothing.
No, same thing. I did not object. Your lordship said that I have objected. I did not object. I can never object. How can I say? If you say that Mr. Mishra said this is not a court, but this is a court of Tahsildar and his subordinate.
Sir, examples will not make it. I cannot. You see, even you also say that he has objection to the petitioner for bail.
He means who? To whom your lordship mean? Your lordship mean to me.
No. You want to say petitioner has objection?
No, petitioner. No, not petitioner. Informant.
Informant has objection.
Why should I have objection? And how can he objection? And petitioner will not move like that. Bail petitioner will not move like that.
It is very difficult to.
No, your lordship is probably not. I'm not clear. Let me see. Here the point is that your lordship can see the petition. I'm placing the petition. That is better to. The opposite part number 2 begs to prefer this application for correction modification of paragraph 10 of the order dated 23/12/24 such and such that during hearing of the bail application, the learned counsel for the petitioner submitted for withdrawal of the bail. Petitioner means bail petitioner. Submitted withdrawal of the bail application, basing upon which this honorable court was pleased to pass an order on 23/12/24. Bail petitioner moved that it is respectfully submitted that during hearing of the bail application, the counsel for the informant, that is what I submitted, that he has objection to the petitioner moving for bail before this honorable court. The honorable court afresh without adopting the proper process for filing of bail application. But inadvertently, it has been reflected in paragraph 10 of the order that learned counsel for the informant submits that he has got objection to the petitioner moving the bail for before the trial court.
Informant means it is he means informant. You can see.
Yes.
Counsel for informant.
Yes, I can never move. I can never submit that.
You say he is to be read as informant.
Yes.
The informant has objection.
No, informant has got. Your lordship has recorded like that. But I say that I have no objection. I can never.
It is not regarding the lawyer. It is regarding informant. Kindly mark.
I can't. Law. It is going to informant also. We are
the prayer is made always on the behalf. Lawyer is representative. Nothing personal about the right. Cannot.
Again, this is lawyer based.
Perhaps you are thinking that it is about the lawyer. No, it's not about.
No.
It cannot be about the lawyer.
This is all relating to the submission made by the lawyer for the informant.
So kindly read para 10. Counsel for the informant again submits that he has objection to the petitioner moving for bail before non trial.
Yes.
To read the entire sentence, he is the informant. If you want, I can clarify it is the informant. Not he means informant.
How can informant is I am submitting on behalf of the informant?
Correct. Correct. That is how it is informant.
The informant, it is informant as well. I am the lawyer for the informant. I am submitted. Your lordship.
You may be thinking that it is regarding.
Not thinking. Everybody in the world will think. Your lordship. Your lordship may ask any of your lordship, your learned brother. They will all think like that.
Why should I ask them? It's not possible also.
But it's a very frustrating for us.
No.
Yes, this is what you have submitted means with what? On behalf of the informant, I submitted before the lordship that I have got objection of his filing bail application before the learned trial court. This is what your lordship has recorded my submission on behalf of the informant.
Submission on behalf of the.
Yes, naturally, we always appear for the client.
Yes, correct.
We can't. We don't even.
Why should I attribute anything to the lawyer? I don't understand.
No. This is. Again, it is lawyer ko hi kuhajibo.
Nothing like that.
How? With all respect, your lordship kindly understand the thing. Your lordship.
Disposal. It is the concern is expressed by the learned counsel for the petitioner that the
Informant,
permissions are made on behalf of the.
We always
Considering the concern expressed by the learned counsel for the petitioner. It is only observed that the submissions recorded are all on behalf of the petitioner, on the behalf of the informant petitioner in the IE. In the state order dated 23/12/2024.
he
Dealing with the IE. Nothing can be attributed to the lawyer.
Actually, it is not an attributed again. It is a submission record which is inevitably wrong.
No.
It is attribution किसी नु है.
Sir, the difficulty is that after some time you also can't remember exactly.
Again, it remember किसी नु है.
Attributed cannot be attributed to the.
It is attribution scope ही नहीं. That application of the
submission is always on behalf of the petitioner. Whoever is the.
The whole point is that whose behalf or not is not the crux of the point here. Here the point is that what is the submission made, that the bail petitioner cannot move before the trial court.
No, it's not that submission.
It is everybody will read like this. If your lordship cannot understand, what can I do? Everybody will read like this, that I made a submission before your lordship that I object bail petitioner to move bail before the trial court. How on earth any lawyer in the world can make such a submission? Yes, that is. Everybody will read like this. Accepting with my misfortune.
It is rather the converse, that instead of moving the trial court, he has moved here.
No. Your lordship directed that I objected his moving bail application afresh before the trial court. I objected that. How can I object that? Under what law I can object that?
Nothing is reflected like that.
Yes, that has been reflected.
You see, as far as the lawyer is concerned, it's not there.
My lord, Lada counsel for informant again submits that he has objection. Lada counsel for the informant. Your lordship can see paragraph 10. I am very surprised at this. Anyway, no. Paragraph 10 dekhantu. Lada counsel for the informant again submits. Did I submit like that? I am stating on affidavit that I did not submit. Lada counsel for the informant again submit that he has objection to the petitioner, means bail petitioner, moving for bail before the Lada trial court. That I say that I did not submit so. And I can never submit so.
Submissions may be because I cannot recollect to.
I collect ho no ho. केबे हवा कथा नु आपण एटा लेखिबा भी कथा नु है.
To err is human.
नहीं. The whole point is that आपण को एरर लागि मते इडियट कहबे छी.
नहीं.
हां सुनिश्चित.
परंतु I could have
सुनिश्चित आपण नाही बोले भी कोन हबो सुनिश्चित कहबे. The Lada counsel for the informant.
The scope is given. I would have written that no one can term.
Again, Lada counsel for the informant.
Attacks, unfortunately, all to the petitioner moving for bail before this honorable court. The honorable court affirms without adopting proper procedure handling the application.
Instead of
Eight are over.
କିଛି ନାହିଁ ଯୋଉଟା ଯୋଉ ସବମିଟେଡ କରୁଛନ୍ତି ସେ ସେଣ୍ଟେନ୍ସ ଟା ଡିଲିଟ କରିଦିଅ ଏନି ଅଦର ଅର୍ଡର ଅଛି
Second solution to think over. Even I don't remember it.
that sentence may be deleted
No, deleted prayer. That will not be fair. See, they will be. It will not be fair.
ଆଜ୍ଞା କିଛି ଅନଫେୟାର ହବନି କିଛି ନାହିଁ ଆପଣ ଅନେସେରୀ କରିବେ
The learned counsel for the petitioner moves. So, Mr.
ଠିକ ଅଛି ଆଉ ଗୋଟେ
I
ଫେର
29 of 2025, I number 2025.
ଫେର ପିଟିସନ ଫାଇଲ କରିବେ
It's just Mr. for the petitioner. He submits that he did not submit when the matter was when the PL appeal number 1425 of 2023 was taken up and disposed of on 23/12/2024 along with the IA filed by the informant, that is IA number dash certificate, where he was appearing for the informant. The prayer made in the IA 29 of 2025 filed on 8/1/2025 is reproduced here. The learned counsel for the petitioner submits that though in the prayer it is suggested that a inadvertent error suggested that to record his submission as he has objection to the petitioner moving for bail before this honorable court. The honorable court affirms without adopting the proper process of filing of bail application. Instead of, he has objection to the petitioner moving for bail before the trial court at paragraph 10 of the order. He shall submit that he shall and submits that the submission of the learned counsel for the informant as recorded be deleted. Though copy has not been served on the learned AG appearing for the state prosecution, the learned AG refers to the IA 29 of 2025 as available in the paperless brief. I'll delete that submission.
Yes.
As suggested by the learned counsel for the petitioner. This in that paragraph 10 of the order dated 23/12/2024.
paragraph 10 the first paragraph cease repealed
ପୁରାଟା
No, no.
He has objection.
ସବମିଶନ ଯେତିକି ଅଛି
One,
Only
only
6
one.
sentences first. Top,
3 sentences
top 3 sentences.
only
Up to trial court.
yes the submission recorded in paragraph 10 of the learned counsel for the informant petitioner court. Learned counsel for the informant again submits that he has objection to the petitioner moving for bail before learned trial court. Full stop. Stands deleted.
That is,
This modification shall be reflected in the order dated 23/12/2024.
that is the only thing I want.
No, prayer is 29 is different, but according to the
Your
submission.
lordship is correct. That is, এটা ଗୋଟେ ଭାବିଲେ ମୁଁ ଠିକ କରି ଲେଖିବ ବୋଲି ଫୋନରେ କହିଦେଲି ଏଟା ଲେଖିଦିଅ ବୋଲି କହିଲେ ଲେଖିଦେଲି ଟିକେ ଦାରି ସମ
No, but you took some time to realize that your suggestion is also contains that. So that I was asking with the same thing. So
only
but any event, nothing is attributed to the lawyer. Never.
ଆଜ୍ଞା ଏଇଟା ଲୟର କୁ ହିଁ କହିବୁ
ନାଇଁ
ପୁରା କହିବେ ଆଜ୍ଞା ଆପଣ ଯେକୌଣସି ଲୟର କୁ କହିଦିଅନ୍ତୁ ମୁଁ ପଚାରିଦେବି ଆପଣଙ୍କୁ ଫୋନରେ ଶୁଣେଇଦେବି ଲୟର ସବମିଟ କରିଛି ବୋଲି କିଏ କହିବ ଆଜ୍ଞା
today no one in the court any
କୋର୍ଟ ଛାଡନ୍ତୁ ଆଜ୍ଞା ମିଲର ଆଜ୍ଞା
including your colleague also.
ଆଜ୍ଞା ସାର୍ ଉନକେ ସାର୍
ଦିଲ୍ଲୀ ପ୍ରଫେସର କହିଲା ଆମେ ଥରେ ମୁଁ ଯାଇଥିଲି ବହୁତ No, not Chief Justice. He was the ex-Chief Justice. But anyway, the whole point is that से जो निजर मिस्टेक जदि मिस्टेक जदि हेतिबो it will not take even fraction of a second to say sorry. And it is not that I don't try. The one Justice Hansaria was there. It's a very interesting thing. Nowadays, nobody reads about the good judges, whatever the international.
Your colleague is looking at the watch.
Who?
Mr. Naik.
No, his last whole night he was praying God. That is why he is not. He didn't sleep in the night. That is why he is looking to the watch. The point is that once somebody
Why God, sir? Why God? So now.
of judiciary in England from whom we have inherited, at least it will take 7,000 years for us to develop. Because I have been seeing the whole difficulty is that that's what your lordship was there, I think, when Waghela told me how was the High Court and how is the High Court now. And I told it clearly, and that was not my saying, that is the saying of the great jurist, and who was not unparalleled in the High Court. So जुगे जुगे उत्थान पतन चले ये जो पतन चली कोटी सरीब के जानी पारे कौन होची एंड वर्चुअली तबने वी डोंट फील लाइक आया आपण गोटे ऑर्डर टे हला देखो किंतु क्लाइंट मान होचन एठी हला से फाइलटा कौन है से फाइलटा शुक्रवार दिन 4टा बेले कले फाइलटा आसला दस्तखत होकर गुरुवार दिन ऑर्डर होती शुक्रवार दिन 5टा बेले से कहले चीफ कोर्ट रे 50 ରୁ ଅଧିକା ଯିବନି ଆଉ 50ଟା ହେଇଗଲାଣି ଆଇଟା ଯାଇପାରିବନି ଆଇଥିରେ ଇଟ ୱିଥ୍ କମେନ୍ସିଂ ଫ୍ରମ୍ ମଣ୍ଡେ 7th ଯେତେବେଳେ ଅଛି ଏଇଟା 8th ରେ ପରେ ଯିବି କିନ୍ତୁ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡିଂ ଦେଖନ୍ତୁ ଏଥିରେ କିଏ ବୁଝେଇବ ତାପରେ ହେଲା 8th ରେ ଗଲା ଆସିଲା 7th ରେ ମୁଁ 7th ରେ ମେନସନ କଲି ଆଜ୍ଞା ଏମିତି ହେଇଥିଲା ଏଇଟା ସେ ରେକର୍ଡଟା ମଗାଯିବ କାହିଁ କନେକ୍ଟେଡ କେସଟା ଆଉ ଗୋଟେ ଆସିଥିଲା ରେକର୍ଡଟା ମଗାଗଲା ଶୁଣ ହେଲା 2ଥରେ ଅର୍ଡର ହେଲା କିନ୍ତୁ ଅର୍ଡରଟା ରିଫ୍ଲେକ୍ଟ ଏଥିରେ ହେଲାନି ସେଟା ହେଲା ତାପରେ ବୁଧବାର ଦିନ ପୁଣି ମୁଁ ମେନସନ କଲି ଦେଖନ୍ତୁ କେତେ ପରିଶ୍ରମ ହଉଛି ବିକଜ ଅଫ ଦି with all respect improper communication or lack of patience mention kali bele nai seta kichhe bane give the memo ଆଜ୍ଞା ମୁଁ ପିଲା ଦିନ ଆସିଛୁ ଆମେ ଛିଡା ହେଲେ କୋର୍ଟ ପଚାରୁଥିଲା yes what are you saying ର ଜୁନିୟର ଆମେ କିଛି ଜାଣି ନଥିଲୁ ନା ଏ କେସ ତମେ କର I joined 6 months ago no it Asif Patnaik BK Bera will help you go through it. That took 2.5 days for hearing a jail criminal appeal because their life and liberty they were talking. And there is a reported case by Justice B.K. Bera and Justice R.C. Patnaik. Then thereafter they said, I filed a memo, they did, then I pursued little bit, you also know my habit. Little bit I pursued, this is better to be hard and pass on all. All right, nothing will happen there, give it. Then the order, the file, the memo went to DR. He is a feudatory lord like Lord, Dhenkanal. Without looking, I had written detail, without looking to the memo, without looking anything, put up next to it. Contrary to the judicial order. If you would have seen the case record, then only you would have known. Then I sent my junior to the register judicial. He again, another feudal lord, sent it to DR. Then again, I had been to him today. Now I will see what he will see now. Tomorrow is there in no court. He has violated the judicial order. Without memo, the matter should have been listed, if not on Tuesday, Wednesday, Thursday, at least today. And I gave a little bit of kotha kohli because he appears to be a very nice gentleman. But the whole point is that we want workative people, men of understanding. We are not here to see the good people. Then he said that you have got how much time you have got? No, I have got 15 years of service. Try to make a legacy of yours. Ita jodi haba se dekhi debo apun namaskar kar dele ja sabu bhul maaf. One of your retired judge was saying
Please talk.
Clark pion re age namaskar e mare khushi hebe jodi bele apun karibe kon. The whole point is that intellectual, I'm not demanding that. Point is that everybody has got the capacity of brain. We are all human beings. We have got all human respect. But your lordship's ability is different because you have been chosen differently. His ability is different. My ability is different. And my clerk's ability is different. He has got a brain stroke, so his brain has become very slow. I am getting very difficult. So the whole point is that in this manner, the judicial order is violated. And in those times, in Justice Gopal Patnaik's time, if the order will be there, passed, it is not come, the DRU has to summon to the court. Because there is violation of the order. You are liable for contempt. So the whole point is that the upward jiba kotha, and
Hopefully we'll have a better time.
after 7,000 years. At least not in near future.
Estimate because of
No.
looking at UK.
I will be very happy.
Mr. Das.
I will be very happy if somebody will prove wrong. But no one has tried to prove wrong.
No, next lawyer is also human.
I इथे कोण करिवे कोणाती सपोज आपण तो आगे सरकारी वकील
Today, sir, next lawyer is also human.
नहीं सरकारी रे आपण पैनल कले I was there in 7 सरकारी पैनल for 7 days 1 week or 8 days. The whole point is that what I will answer give to him. Because the order was passed, I sent an information. He filed an affidavit on my instruction, but there is no order, and I've been trying to list. Of course, 15 वर्ष भी तले कहते सबुतर बड़ केस होचे हाई कोर्ट रे लिस्ट करेबा हां
I was thinking, but I did not say because it's a part of the practice that's very difficult.
And how
the system is overburdened.
No, I have not resorted to the thing. Those who are not mentioning like me, big councils, the set semana केमती करने मु जानि that I am not resorting to because I
discuss that, but that is
এই জিনিস গুড়াক সেটা দেখলা বেলকু সে 7 দিন উইথ কমেন্সিং টা সে ক্লার্কটা কাকি বসতিও গতেও সবল গতে ভয় নথিলে কাম হুয়েনি আগে আগো আমি চাললা বেলকু তমানে উইথ রেসপেক্ট ইট ইজ নট দ্যাট উই আর ভেরি বিগ পিপল ফর কনভিনিয়েন্স এন্ড এভরিথিং পিপল আর গিভিং ওয়েজ হিয়ার নোবডি বদার্স এটা হউচি কোন There is no difference between the, I mean, Malgodam and the High Court Bar and Baranda and everything. The way you move, there is no distinction.
And don't be too harsh to your colleagues also. Maybe harsh to the judge. No problem.
You give me example so that I can become very sweet.
No, not to the colleagues actually. Young people are to hope they will make it this profession.
All are here coming on survival. They have got nothing. They don't see any other thing excepting currency. Nothing. If you don't believe your Lord me, then it's something different.
Survive. Yes, Mr. Das, Mr. Himanshu Das.
item 13,
But I'm very sorry that I said that is the only sentence I wanted to listen.
No, at least now, I mean, both have been taken care of.
Which one?
29 and
दरकार नहीं है. This is simple thing. आपण जो with all respect है, आपण जो कहले जो stamp reporting कथा, don't mind, don't take it to your lordship's heart. Your lordship is the final authority to see the law. Stamp reporter is the clerk. Stamp reporter कहाँ कोर्ट जानती?
Yeah, I did it. Whatever I am saying, I don't presume that everything I say is the final line on that thing. The learned district judge, by letter, learned 13 letter.
item 13,
The learned additional ADJ, then additional district and session judge from presiding officer, Special Court under POCSO Act, Rayagada, by letter dated 11/6/2025, addressed to the registry, has sought for extension of time for completion of trial in TR number 10 of 2023, arising out of so and so PS case number 26, dated 10/4/2023. Don't even actually say R order kare it will sell it. Case number. In view of the said letter and the facts stated therein, the time for completion of the trial is extended till end of end of November 2025. The learned special judge is also requested to take all possible steps to expedite the trial in view of the statutory mandate. Total lines होते हैं ऐड CTP total line. The trial court is process thing.
14,
Because beyond time also they may be present in BC. Must understand that. So not stopped anywhere. With reference to the order passed by this court dated 18/11/2024. At paragraph 7 of the state order, the learned trial court was directed to complete the trial expeditiously. By letter dated 5/3/2025, Assistant Session Judge Purushottamapur has requested for extension of time. Accordingly, the time for completion of the trial is extended till end of August 2025. The learned Assistant Session Judge will also ensure to take all steps for expeditious completion of the trial in view of the statutory mandate. Judicial, it is better order to the learned Assistant Session Judge Purushottamapur. Yes, next.
15,
Your Lordship, the order has been complied with. That is, the authority has rejected their representations on 25/4/25. Lordship,
In his absence, shall I pass or
Lordship, I will.
it is submitted by the, or I'll grant liberty to revival.
A separate cause of action, he can file it because rejection is
15,
there.
petition of blank chat because it was given 430.
Order has been communicated to him.
The learned AGA submits that order dated
17/12/21.
17/12/2021.
Yes.
Not in time. You are
Not
saying
in time, not in time.
17/12/2021 has been complied with, though belatedly. The order passed by the authority has been communicated to the petitioner
Yes.
on order dated what?
Order dated 25/4/25.
25/4/2025 has been communicated on, passed by the authority has been communicated on has been communicated to the petitioner as per the instructions issued by the Honorable AG. It's further submitted that the opposite party alleged contender expresses sincere regret for the delay in compliance of the order. Accordingly, the petition stands dropped. You have not filed, you have filed any show cause,
Not filed.
only compliance you have CRC.
I'll get a photocopy.
The copy of the order shall be also,
I'll give it to you.
shall also be, the copy of the instruction enclosing the order passed by the authority shall be kept on record. Copy of this order shall also be intimated to the learned counsel appearing for the petition
Petition.
by the registry. Yes. Passport is still again.
No.
Thank you.
ସେଟା ଜେରକ୍ସ କରି ଆଣି ଦେଇଦେବି ସେଟ୍ ଦେଇଦେ ସେ ଜେରକ୍ସ କରି ଆମ ଫାଇଲ୍ ଆଣି ରଖିଥା ମତେ ମୋର କପି ନାହିଁ ଆଉ ନା ସେଥିପାଇଁ ତ କହୁଛି